In Nevada, in a child custody proceeding, when one party has committed domestic violence, it can invoke a presumption against that party having even joint physical custody of that child. So how this plays out is that a court has to make a finding that there actually was domestic violence committed, and that's either through an evidentiary proceeding in the child custody case, or it can be through a criminal case and having the proceedings that happen in the criminal case amounting to meeting that burden. Now, once the court has actually found that one of the parties is a perpetrator of domestic violence under this standard, then that person has the ability to rebut the presumption against them having custody. And so that can be, that can look a lot of different ways. They can come in with defenses of, oh, it was a situational issue when we were separating, or, various defenses as to why that domestic violence that has been found to have happened isn't something that should result in that parent not having even joint physical custody of their child. And so if a parent does rebut that presumption, then they can have custody or joint physical custody. If they do not rebut that presumption, then the court has to make findings that the visitation schedule and the orders are sufficient to protect the child or children that are at issue in that case. Now, if you do have a criminal case that is regarding that domestic violence, there's a few different things that you need to be aware of. Now, one, if there is a criminal case that resulted in an actual conviction against domestic violence, that meets that standard of someone having committed domestic violence in order to invoke the presumption against them having custody. If they have a criminal case that is for something else, not domestic violence, that might not be as conclusive, but it's certainly something to bring up and to convince the court that whatever criminal charge they did get is actually domestic violence, in the custody context. Now, our custody statute references the criminal statutes in its definition of domestic violence. And so the criminal domestic violence and the custody presumption domestic violence are one and the same under our laws in Nevada. Now, if you have a situation where someone has pled out in the criminal domestic violence case, that can play out in different ways. So if they have taken a plea deal and pled no contest to it, and so they have a conviction, but it's a no contest plea to that domestic violence charge, that's handled a bit differently than an actual confession, a plea that confesses to it, or an actual conviction for it. And so the fact that there's a no contest plea is something that the court can't take into consideration, saying, okay, this means that they committed domestic violence, but it doesn't exclude the ability for you to go to court and actually testify, give evidence of that domestic violence incident, and for the child custody judge to make a determination that domestic violence occurred for that same incident that resulted in a no contest plea, or in some other criminal consequence other than just a conviction or a pleading guilty plea to it. So in Nevada, it's very important to make sure that the courts know about domestic violence. And even if there is domestic violence that occurred that doesn't rise to that presumption level, these might be situations where it's not 100% clear what happened, or maybe the evidence isn't as clear. Whether or not there was domestic violence is something that the court has to take into account when it's considering the best interest of a child in any custody decision as well.